And if the order dated 22nd June 2026, my lords, the present dispute in the writ appeal is covered by judgment of coordinate judge of this honorable court, my lord, in 1469 of 45. Now, the last part, occasion, my lord, please to direct the Lord State Council to take necessary action whether any.
Yes, the same order has been reversed.
Yes, my lord.
So what remains?
No, XLT has been filed. My lord wanted to know whether it has been challenged.
No.
XLT has been filed. That is the instruction. But they say, my
So
lord.
whatever if the same order is reversed, then what remained? So committee and the amity of the judicial discipline demands the same judgment.
Yes, my lord.
Where is the judgment?
Once again, I'm giving you.
I will do. Yeah.
So operating focus from paragraph 5, my lord. Case 4.
Oh,
Deputation as
that means the court refused to interfere with the impugned order.
From the honorable single judge accused, my lord.
No, division bench. This is the division bench order you have handed over. And this court says I am not inclined to interfere with the impugned order.
that you are seeing the single.
Oh, sorry.
Page it.
Sorry.
Page it.
Sorry.
For clarity.
No. You have.
No. I was looking at the single bench order because you have. That's a most confusing attempt which you have made. Both the orders are there. Impugned order is with us. Why you have included the impugned order?
Sir, index ta kar deythanda subidha aitanda. Kama sentanda.
Sorry.
So posting as RI you wanted to retain. So he was Peshkar. Deputed as RI. So all
Patricia, I want that I should be given the benefit of RI.
So he cannot be reverted to Peshkar, which learned single judge refused, division bench restored.
So that is what is, yes, nothing can be done. Yes. And the challenge is to a single judge order dated 12/8/2025. Just find out whether it is the same order.
Same.
Hmm?
In view of this,
Just.
80 page.
30719.
Issues 719 has been disposed of in the light of mother.
Oh, just 1 minute, sir. What about challenge? Any challenge to 21472 of 25?
Separate counsel, that has not.
I do not know. I just wanted a query.
It's pending.
It's pending. Lakho. दो
The lot may take up the matter that is WA 755 of 2020. Because their delay is there, your notice has already been issued. It's 23 days delay. If delay-
Who is the other side?
I am appearing for the.
23 days delay, sir. Yes. Same order. Delay control. That I have said that. Out of original law, open up down here. So that has, we have to fix another day for that. Next week, this will be accepted.
Let him serve a copy
Oh
of.
my God, I will start.
Please, sir. Let it be done.
Item number 3,
I please your lordship. Last time lordship was sought for one judgment of the lordship. I have searched in internet. I can find that whenever the lordship on sanction court that we have not regulated that person. I have searched many times, but I can't find. But I have found the lordship judgment. That WA number 40/2025, the lordship has regularized draft respondents.
Yes. Yes.
The respondent was working as a daily laborer, the residential of the chairman of the then or administrative tribunal in 2011.
2000?
While continuing to as an unskilled
He
laborer.
was appointed for the first time in 2011.
11.
Okay. Then
He was not appointed, he was engaged, no appointment letter was issued, he was simply engaged as an unskilled laborer on railway basis. No appointment letter was issued. While he was continuing there as such, as a laborer, four posts are sanctioned by the state government for appointment of peers. Appointment of peers, regular peers.
Peons.
The sanction. After the sanction was made, and it was categorically indicated in the sanction letter that 2013 rules, that is contractual appointment rule, that rule is to be strictly followed and appointment accordingly is to be made in accordance with laws. But without following this, the appointment letter straight away given to the present respondent.
By whom?
By the register of the Orissa Administrative Tribunal. And he is allowed to continue. And he continued as such for 6 years. After completion of 6 years, he made a recommendation to the State Administrative Tribunal Vice Chairman, saying that my case may be regularized because I have in the meantime completed 6 years of temporary
So
service.
where is that rule of 6 years?
That is in the 2013 rules. That rule prescribes.
So if it is prescribed therein, can you defy?
No, that rule has not been followed in the present case. That rules, the post was created clearly stating that rule is to be followed. And
So
accordingly,
rule says that if anybody has continued in the post for a period of 6 years, then in that event, he is entitled to get his services regularized.
In this case, without the knowledge of the government, appointment has been made.
Now, that
And
rule, that rule says that all the appointments
Yes,
or engagements are treated to be contractual.
contractual.
After completion of 6 years
Yes.
as such, in continuous service,
Where is that rule?
then
The rule I have added.
that is now repealed.
That is now repealed. Now,
In 21, 22.
So he claimed his right prior to 22.
when the matter, he claimed the right because earlier the interpretation was filed and the interpretation was disposed of, saying that.
Representation.
Considered. His
Okay.
representation was considered and it was rejected because his appointment was illegal.
So there is a finding that he has worked for more than 11 years.
No, 11 years.
No,
from the date of
there is a
disposition of the
finding.
matter.
There is a finding.
That is the fact. That was not the challenge.
I was just going through the Leonard Single Judge's observation.
Yes. The learned individual on the impeachment procedure with the matter, as if he has been appointed against the post of peon from the inception and he allowed to continue and thereafter 6 years completed with him. On the basis of that, matter has been proceeded and ultimately order has been passed. Even if the 2013 rule has been repealed, Under the repeal provision, he is also entitled to.
No, there are two aspects. When any provision is repealed, action taken during the currency or lifetime of the repealed the repealed rules of the act, does it get automatically effaced,
No,
or there is a saving clause which saves any action which has already been taken?
during pendency of this case, no action has been taken.
I am asking, sir, this is what one can say, that because of the pendency of the litigation, the matter has now become infructuous in the sense that the act has also been
No,
repealed.
that is not.
But if the right has accrued when it was during the lifespan of the repealed act, and he asserted such right,
Yes, there is a
if
repeal
you
of-
delayed the consideration,
Yes, in the repeal.
can you reap the benefit of your own wrong? I'm asking you this.
My submission, there is no question of any wrong on the part of the government. It was appointment was initially made as an on-skill level.
Please tell me that what is the rule of 2013 which
Yes,
or which talks about such
I'm
situation?
sorry.
Where is that provision of 6 years?
Yes,
Where is that?
so the 2020 page
Please.
was 175. Page 175.
Yes.
Relevant portion is applicability at page 76, rule 3. These rules shall apply to group C and group D foods, which are filled up by way of different direct recruitment. Provided that state government may by notification exclude any post from the purview of these rules. They shall also apply to the categories of contractual appointments made under Rule 4 from the date of contractual appointment, if any, made under Rule 5. If an appointment is made under Rule 5, then that will be applicable for contractual appointment. These rules shall not apply to the Group C and Group D posts for services and functions like watch and ward, sweeping, cleaning, gardening, etc. Manpower required for such services, functions shall be managed by outsourcing basis. These rules are also applied to the contractual appointments made under temporary plans, therefore temporary establishment, then Rule 4, that is relevant. The categorization of existing contractual employees.
no.
Each case is that I was a existing employee at that time.
Oh, I understand,
Yes.
sir.
Yes.
Now,
Rule 4 and
madam,
5.
there are two aspects. Let me understand, sir. You may have read it. I'm reading it for the first time.
Yes.
Madam, first you tell me that your appointment was made in 2011. How you were getting a stipend or a remuneration or a salary or a wages, whatever terminology it is used, what? How you were getting?
Who was disbursing?
Just I'm asking you, sir, how it was done. Can you show me that, what is the mode of that payment? No, no, daily wages, I understand.
ପାଉଥିଲେ କୋଉ source ରୁ ପାଉଥିଲେ finance ଟା? ଟିପ ଚିହ୍ନ ଦେଇକି ଯୋଉଟା ନଉଥିଲେ ସେଟା କୋଉ source ରୁ ଦଉଥିଲେ ସେ ପଇସା? ସେଇଟା ସାର୍ ପଚାରୁଛନ୍ତି। The concurrence of Finance Department.
Finance Department and dated 12/11/2003, last line, my lord.
Yeah.
Their service condition and emolument shall be governed by the said.
Paragraph 3 I'm reading.
No, first paragraph can be seen. 41. First 41. 41. 41. No, 41. Page 41. Page 41, paragraph 1.
The engagement is a daily basis, vacant post.
Why
Yes. Then what happened? Where is the government decision? Where is the government
I
decision?
will definitely.
51, page 51.
It's a 5 page 83.
No, where the
Which you have
order of the
challenged.
government, if challenged in writ petition, is at 51,
No, my lord, 83.
83.
So fine,
It's a
83.
fine.
See, you're referring the same order. What of June?
What is then 51?
51 is the, my lord, later of the, there
You
are,
have enclosed writ petition as such, and including the annexers. You have repeated the letter,
Same order twice.
same, not twice. She has enclosed the entire writ petition copy as an annexer.
Right.
So those documents have been repeated.
Repeated.
So that is what I'm asking you. We got confused with that.
I thought that.
But 51 you have enclosed and now you are drawing attention to
This is there. Dr.
81. That is,
Yes.
I've seen. Yes.
My submission is appointment is neither a existing employees nor it has been appointed under the 2013.
Were there any executive instructions or rules invoked with respect to contractual appointment or daily wage employee engagements?
I think,
Yes.
how they have, why that been, they have been appointed, that is, this elaborate.
Payment was made on the receiver, putting a stamp paper signature.
What
On the font, from the font.
saying?
Font, that I have to inspect.
You have filed a counter affidavit.
No, fonts are paid by the outside municipal government, not by the government.
Then from where? Somebody in,
Yes, yes, yes.
outsider is making the payment.
Post was there, that no.
Sir, this is something for sir.
No, now Central Post came in 2013. 2014.
Sir, I tell you, if you go through their documents,
Yeah.
Paragraph 1 of that particular nodal officer's, the recommendation clearly states
Yeah.
that there was a vacant post, sanctioned vacant post.
No.
Into
My entire case, there is no
in
port of call at all.
2011, there was a vacant post. That was, they wanted to fill it up
No.
to a daily wages.
My entire case, there is no port of
Then
at all.
OAT was created when, let us,
When-
Mr. Swine, let us understand.
Yes, that
OAT was
99.
created or substituted when?
2099. The rules came 99.
It has not come. You, neither you will be there. nor I will be.
1099.
Huh?
1099.
So,
It was effective
1999,
December. Yes,
the OAT was created,
yes.
correct?
Yes.
When you sanction the OAT
Yes.
to be established, did you not sanction all the menial posts? I'm asking you. Did
Beyond
you not
that,
sanction? Do you think that the finance department, when it sanctioned, that it does not sanction the vacant post?
it is not that post. It is a post.
Sir,
the
who
resident.
knows if the OAT, the nodal officer has said that we have taken him on the vacant post.
But subsequently, after creation of the post.
No,
No, 2011, there is no post.
no, please come to paragraph 1.
Yes,
Read,
yes, yes.
what it says.
Page 153.
Correct?
With reference to the
Page
letter.
41,
Page 41.
please read.
Yes. Yes. With reference to the letter on the subject Saturday.
No. 1,
One. For smooth management of official work, a meeting was held on 17/6/2011 in the chamber.
remember the date.
Yes, 11. In the chamber of the then Honorable Chairman consisting of high dignitaries, the Chief Secretary, Special Secretary, Consul,
No, not so.
and Finance Department, Additional Secretary,
GA and PG department, special
Yes.
secretary, finance department.
to resolve the then going problems in OAT out of his engagement of daily wage workers in the vacant post of class.
What is this?
Was it,
Post of group four,
was a
that
matter
is
of
group
which
D.
was resolved in the same meeting.
So-
It was
So
resolved,
there was a vacant post of group 4, that is a group D now.
but he is not appointed against that post.
What are you talking then? Paragraph 2 and 3
Yes, sir.
comes and says.
In the
it is-
same year, in 2011, 6 number of unskilled laborers on daily wage basis were engaged
Huh? Please read.
by inviting applications to notice board
Yeah.
by number so and so that 9/9/2011 to
Yeah.
perform the duties in the residence of Honorable Chairman
Right.
and member OAT only on daily wage basis as per the rates prescribed by the Labor and Employment Department.
Yeah.
In total, 21 number of applications were received to appear in the interview. Out of those candidates, 6 out of 21 number of applicants were selected to appear before the selection committee on 12/10/2011.
Correct.
The date of selection, accordingly, Mukunda Prasad Malik, present respondent, was engaged on daily wage basis as an unskilled labor. He was not a peon at all, an unskilled labor.
Pune is a skilled labor.
As
Let me correct my.
per the rate prevalent under the council. And no
Let me
appointment.
correct. Pune is a skilled labor.
There are different types of peon, watchman.
Sir,
And
I am again asking you, sir.
yes.
There mean this, we are not concerned with the Pune in that sense. Pune comes under the group D category.
Yes. No, then I'm placing the entire.
No,
So,
that is what
they have
then he
said.
says that he was engaged.
No, he was engaged, but
Yes. Then in paragraph 3 says that there
Yes.
are 4 posts sanctioned for Pune.
exactly. So earlier there was no post.
Sir, what are
It
you
was
talking about? He was appointed in the group 4 post, vacant post.
Well, it was established in 1986.
It is a rules came subsequently.
85.
Rules came subsequently. Rules was not there.
So according to you, he was not appointed in the vacant post of group 4.
Yes, that is my case.
That's your case.
That is my case. He
And
was not appointed subsequently when
define the method of a person who has appointed. Can you show us that on that day, that is in 2011, there was no sanctioned post of group 4? Give.
Sanction
You say
post-
not appointed, give whether there was any sanction post of group 4
Sir, this.
in the OAT.
This notice board system. I think, in Mr. Tripaঠি's case, you have to take it. I have held in single bench that, this notice board, that is your creation, that is the publication. If you are not published anywhere, in a newspaper or so, but notice board publication is to be treated as publication, as required under this.
My
Employment action is now under the Supreme Court has said, employment action.
my submission case is not coming under the 2013 rules. 2013 rules specifically provides who are the existing contractual employees and who are the regular appointees under the rules.
You have gone too far. Have you read the rule 4,
Yes, Madhu.
sub rule 2?
Yes.
Sir,
I'm also surprised with this kind of a rule.
no, another rule, another notification, resolution is there on the same day in 2013. Where is that, madam? Same. Notification, finance department notification, calling out certain criteria who are appointed prior to 2013. Another notification by way of resolution, resolution by way of notification is there.
That came in September and the rule came in
Yes.
in November 2000.
Yes, very good. Your case is not falling within these rules. Because he is engaged prior to 2013. Another notification is there. You have not seen.
Neither, madam, you have taken care of this. If my brother has a direct knowledge on that, then
Yes, it's lawsuit.
why you do not make a walkout?
Last occasion lawsuit directed that there is a judgment of this bench that we have denied sanction payments, but I find that your lawsuits are allowed every case
No.
and more than the
That is on
single bench.
a different, because these facts were not known to us. These facts were not placed in that extensive.
So that's it's all math and all this thing is exactly the my fact is.
We may take a dissenting view.
No,
That's why I-
verified. I tried to verify.
Yes, that is
That
that is in my learn.
That notification.
79 2013.
So those, I think, I am correct that prior to 2013.
Do you have the copy of the notification?
Well, I have the copy, but I
Can
am not.
you give it to me for my benefit?
Well,
I have not seen the light of, I have not seen it.
No, I may be wrong, that's why I'm thinking of.
No, you do this, if there is a notification, if you say that you have seen it, then you give it to me.
Well,
This is group C.
take out the copy.
These rules are group C, group D contractual appointment rules. 13. I believe there was another notification.
That is 79 2013.
Ah.
And her case mirror is to be taken care of in terms of that notification.
Because you have been dealing.
Yes, yes, they also, this is the commercial tax department.
You have cited, I think before.
Yes.
That's it.
Please produce.
Well,
Something for-
I'll take out.
Yes, yes.
Now I took it.
And in another 2014 also clarifying this.
Yes, 16-1 2014.
Ah,
16-1
In
2014.
2014, clarifying this.
Yes.
Another notification.
To regulate that.
Please give it. Keeping this matter on Monday. Take a printout and then.
Yes, yes.
The two notifications.
Yes, yes, yes.
Clarifying this. 2014.
Is that judgment?
Item number 4.
If please allows. On the last date of hearing a lawsuit, had expressed a doubt regarding the maintainability of the petition, sir, madam. The maintainability of the pre-taxes as well as the relief in light of the judgment passed in Radhesham. Because the order that was impugned before the learned single judge was the order that was arising out of the history of the order. And that was also fast tracking that arose out of the order from the civil self-election. In that light, my lord, the wheat itself was not maintainable under 226 law.
That is, I think we have also held that against the judicial order, or in the judicial proceedings, it is Article 247, not 226.
Because CMP, because had it been an application under 227, the nomenclature will be different and it will go.
True, that is what I'm saying, the nomenclature would have been different, the consideration is different. Even the roster has to be there upon a judge to take up those.
Right. That is the lordship judgment in NKC projects line.
So,
Well, this is a case where the REIT was not referred by the minor. REIT was referred by the respondent.
I am asking the respondent to maintain the maintainability of the important. No, yes, sir.
Your lordship,
You are challenging an order passed by a judicial law
under
officer
227,
in a judicial capacity.
it has to be read as a, will be treated as a petition under 227,
Correct.
not
Whether
226.
the learned judge who disposed of the matter
Matter
did
as
have the
227.
jurisdiction, did have the, I mean, the determination of 227.
Yes, ma'am. The
That
judgment is there.
shows the list of the determination.
And your lordship on the other
Was
day,
the list of determination on that day.
CMP ତାଙ୍କ ପାଖରେ ନାହିଁ।
CMB not, that WPC registered upon
That is not why I was
227.
asking. 227 is listed under, categorized under CMP, not WPC.
WPC. ma'am.
Put it. Article 227. Article 227 is under categorized as WPC.
I will give
By
the
this
note.
time I have
I'll
learned
give the note. I will
that
give
normally
the- Then I
anyhow.
brought out the
I do
entire
not
note.
know, first thing is show me the determination that we had 227 passed. On that day when it started.
ତାହେଲେ civil miscellaneous question ଟା କଣ?
Suit to, ଯୋଉଟା directly suit to arise, which is arising out of a suit, not special statute. There it is nomenclature as CMP. Where it is arising out of special statute, it is registered as
What is the date of the impugned order of the single bench? Don't go. This one the commission. What is the date of the impugned order of the single?
10/3/2026. It was reserved
10/3/2026.
2026.
Can you give me that this I mean the roster of 10/3/2026?
Right. It was reserved on 3/12/25. Right.
You know, on the day of interference with sin. Give me.
Yes,
roster list of 10/3. Or which judge? Just give all the justice for that.
for judgment rendered by Chief Justice Mathur in that Pashupati Adhikari case,
I know.
which has been reported in 2003 Calcutta decision online.
That is the.
Whether that is a personal
Not
designation
designation
or a
or it's
court.
a trapping of a court.
Tapping of a court.
It has been held, it is a trapping of a court.
Court. It
I
is a
know.
court. Yes.
I know it, and the matter is pending before the Supreme Court, till date not decided.
In fact, in
Thereafter,
there is a
Radhashyam judgment. After Radhashyam judgment,
Sir,
till-
only one thing is, our decision is that whatever be the reason, if it is a court, that 227 is the proper remedy.
proper remedy.
Look at the determination, whether he has the determination of 227. Even if he treat the petition as 227 because it is a combined writ petition, then 227 power was given him to. No power of 227, sir.
Writ petition regarding service concern area
Is it writ petition means 226 application?
227 man. My lord, there is a notification I will submit to your lordship. Any writ petition arising out of special statute, then it will be nomenclature as a writ petition. If let's may take up next week, I will satisfy your lordship.
This is arising from election dispute.
Yes, it is arising out of election dispute. It is not from a common law civil suit and appeal.
No,
not
I
thereafter.
understand what you are trying to make a distinction in that.
Yes.
That if it arises of a suit or a appeal, regular first appeal under section 96, the position would have been different.
Different.
But if it is arising out of a special statute where the power is given to the court, then in that event, if there is no further provision of the second appeal, then in that event, writ petition is the only remedy.
Only
remedy 226.
My lord.
Even if it is not there, 227 is there. According to you, those are registered as the 227.
227.
But I do not think it is a writ petition anyhow. I will say category. The categorization is one thing, and the power to be exercised by the.
My lord, there is some notification.
Because
I will produce your lordship to those notification. Let it be taken up next week. Any day next week, I will submit the notification. Honorable court and also very full way that Muhammad Saud, yes, many cases.
Sir, I understand. I am not in dispute with those merit of the case. But only thing is, we were more concerned with
whether it will be nomenclated as same
exercise of the jurisdiction.
Right. Your lordship is absolutely
If
right.
there is an inherent lack of jurisdiction, even if you have the best meritorious case on the earth, but you cannot sustain that order if the authority or the court lacks inherent jurisdiction.
Right. Absolutely.
So this is what we are more on the jurisdiction part of issue than on the merit.
Even the present setup, it can be challenged anywhere, but a writ appeal is not maintainable here because it is a judgment passed by the honorable single judge.
No, question is if it is in exercise of the power under Article 227, no further appeal lies.
Yes,
I am conscious.
Yes, ma'am.
If it is an exercise of power under 226, then the appeal lies.
Obliged.
It's no difficult.
Yes.
The question now arose 227. If the 227 power was given to him or not, that's the only question.
Next week I will
And
submit all
whether the
notification.
categorization of writ petition in relation to 227, whether it will take away the power or load the power of the judge.
Obliged. Next week any day.
By chapter 15 High Court rules, so lordship may pay. It clearly says that any application under Article 227, it will be nomenclature as CMP. It has been accepted that all applications will under 226 will be nomenclature as WPC, but if it is an applicant only under 227, it will be CMP. It will file.
No. What he is trying to make a distinction. He says that if it arises out of a suit or a first appeal, then in that event it has to be registered as single appeal. But if it does not arise out of a suit or a first appeal, then normally it is registered as the writ petition, civil.
Yes.
So that is here, he wanted to make a distinction.
It is not a court and.
It is not arising of a suit or a first appeal,
This is.
but under a special statute.
Yes, ma'am.
So that is Gram Panchayat Act. From Gram Panchayat Act.
For that one, and your lordship's order in NKC projects, that was an order arising out of a commercial goods act.
Please make a distinction. There is a suit before the commercial court.
As
Commercial court is designated as a civil court to decide all the civil cases, civil disputes. That suit has to be filed.
mine. Regarding that also, I have a judgment that I have compiled in this compilation, my lord, where the Supreme Court has discussed, where there is a reference to district courts, and there is no more, nothing more mentioned in the act, then it is to be understood as a court under the Civil Courts Act, my lord. That was a case in a eviction act.
Are you not understanding what he is saying? You may say everything we have decided. We are conscious. What he says is categorization of the writ. According to him, if it is categorized as a writ petition, then the determination of the roster, as it's called here, we call it determination there in the Calcutta High Court. If it says writ petition pertaining to the contract, then what he says is the writ petition means both 226 and 227. Because it is captioned as writ petition. This is what he wanted to make a distinction. So let us see.
Well,
I have to argue to make you understand what is his argument. Give me that.
yes, ma'am. Sir.
Sure.
But if we have 20th, ma'am.
I will correct myself in the roster. I will introduce the other roster. There it is never used as a writ petition. It is always used as an application under Article 226 of the Constitution of India relating to panchayat, transport or something. That's all. No word writ petition is used in the determination.
And in Sabinath Radhesham, it has been
No,
mentioned.
Savilal is, Radhesham has very categorically said.
Yes. Will it is nomenclature at 226,
So that is
227?
why I say Pashupati Adhikari,
Yes.
why I cited that it is not a persona designator that officer is exercising.
Right.
He is exercising as a power of the court. If it is a court, then the order passed by the court, not amenable under 226.
Right, ma'am.
So your writ petition should go. Anyhow.
Item 5.
When?
20th, ma'am.
Item 5.
Present appeal, the petitioner, the appellant has approached this honorable court with a very limited grievance, that his unutilized leave salary may be released. Considering the limited grievance, the learned single judge has directed to consider the representation to the respondent number 1, my lord. The same was not complied and a contempt petition was filed, my lord. And complying that contempt petition, they have only released the principal amount, my lord, not releasing the interest amount. They have only released the principal amount, the unutilized leave salary principal amount, and not the interest levied on it, because due to the delay made.
Paid for,
My lord, we have paid for it.
where is that?
My lord,
So, page
annexure
12,
5
page
to the writ
12.
petition.
Page 12, the learned senior has quoted.
My
Quoted
lord,
your prayer.
my lord,
So that's true. I'm just asking before the authority the representative.
my lord, annexure 5, my lord, to the writ petition. To the writ petition, my lord, disposed of writ petition, annexure 5.
What the- It's. So now I mentioned file to the. I mentioned, I don't know, there's a representation. I want your representation, which is this total.
My lord, representation, I have not annexed it in the writ of the.
Or like, if you are not claimed the interest. then
We have
whether-
claimed the interest in the writ.
Show us. We have to satisfy our conscience.
We have made it in the prayer, my lord, and
Sir, for
considering.
the
the
first
prayer-
time, if you make a prayer in the red petition, that will not do. You'll have to pray before the authority as well.
My lord, this same prayer was made in the writ petition after the disposal of the first writ petition.
I am asking you the first red petition when you came. What
My
was
lord.
your prayer in the first red petition? Show us.
First writ petition is quoted in para 3 of page number 20, my lord.
Yes.
There we have prayed for 18% interest.
The first question. That was 17/8/2023,
My lord,
first writ petition.
my lord,
Page 20 of the writ petition.
writ petition.
That's not taken follow-up action.
Mixture 4, my lord.
This. The nature of.
Mixture 4, page 16, my lord.
He has received around retirement dues, except when it was given the house and the place.
Who is for the other side?
No, see, the original writ application which petition was filed, in that writ application, a prayer was made to consider annexure 4 and also grant of 18% interest thereon. The Honorable Court directed that annexure 4, which is the recommendation made by the Assistant Chief Conservator to the government, that is to be considered, and with regard to interest, no order has been passed. Accordingly, the recommendation has been accepted and sanction has already been made in his favor. He has already received the amount. Now he is claiming 18% interest, which has been denied by the Honorable Court in the earlier case.
I do not find that.
That is the extent that he has
Where is that?
indicated in the picture, paragraph F, page 5 of his petition. Page 5 of his petition. That has been taken note of and this Honorable Single has rejected because of that reason. Page 5.
I'm just looking at the order, earlier order. Election file.
17/8/2023.
7/8/2023,
Yes.
to take a decision on the recommendation of the Assistant Chief Conservator of Forest, hide this letter dated 7/8/2023 under answer 4. So that has been considered and the writ application would be of 6 weeks. That is the direction given. That direction has been complied with and payment has been made to him. Now he is claiming the 18% interest, which has not been granted by the earlier.
Some kind of thing.
In paragraph 5 of the interim order, the
Make a further representation after this order of 13, this week, 17.
Hello. After the con-
Was petition disposed of.
My lord, we have approached the authority. After that, content petition was filed.
Making a fresh representation,
My lord,
where is that representation? After 17.
it's not annexed, my lord. I don't have that representation right now, my lord.
Then what do you expect?
My lord, it was,
Anything you keep in your pocket, the court will presume it.
my lord, it was duly ordered to consider a grievance presentation.
What is the, that he is going by a strict rule of interpretation.
My lord,
The court has simply said that you act in terms of the recommendation of that, of the additional chief secretary. That's all.
my lord, I may.
No, by the assistant chief conservator. That you should consider the recommendation of the assistant chief conservator. That's all. But it does not talk about the interest. You claimed an interest.
My lord,
Court has not said that you can make a further payer. The court simply said that you dispose of in accordance with that recommendation. Nor saved the any consequential benefits to be extended to you. If the court have not passed an order, though you prayed for an interest in the earlier regime, then what is the law? The deemed to have been refused.
it has not been expressly.
Then I think you should know section 11, explanation 5 of the Code of Civil Procedure. If they come from a civil chamber, then explanation 5.
My lord, what I.
Is res judicata. If it is a res judicata, can you reopen by virtue of section 12?
My lord,
Section 12. Can you call the action?
my lord, in light of that, I have a judgment of the Calcutta High Court where a second petition was maintainable.
When? 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 Even if the prayer was made in the earlier expedition, second expedition is
It was-
maintainable. I have to accept it. Tell me. For implementation of an order, I have no inkling of doubt that a repetition to implement the earlier order of the court is maintainable.
My lord.
I can give you a Supreme Court judgment also. Why you are going?
Our division bench, High Court.
My lord,
Our
it is there, my
High
lord. It is there, my
Court.
lord.
Our
Single-
High Court.
My lord.
So why are
It
you?
has this. No, my lord, on the other day, on the-
Question is that, had you not prayed for, you could, that is the whole problem, because in earlier order, the entire prayer is set out, which includes an interest.
my lord, there is another judgment of this honorable court where the court has deemed it fit to put in levied interest due to
That
the
is
laches of the
discretion.
authority.
That is the discretion.
That is first court.
It is the first court, my lord. I oblige, my lord.
So
The
successive
petitioner has served
on the same cause of action,
Right.
which is deemed to have been refused in the earlier one.
We
Can you
appreciate,
disconnect?
but you ought to have. That's why I'm still saying whether you have made a further representation. You have not filed any document before the single bench or before this.
What I pray, my lord, for petitioner since 2018.
Maybe, I understand, but
Is the laches of the authority that they have not paid the
no,
amount.
you should have.
For that we have prayed for it, my lord.
No, but the court has not granted. The authorities have to go by a rigor of the language and the intention of the court.
My lord,
The
the
paragraph,
Lord,
I think 7 is very laudable
my
of
lord,
the earlier order.
the
7 is very clear.
Supreme Court has clearly accepted the limited grievance of the petitioner, my lord. And he,
So what about this law? I am bound by the law.
my lord,
What the law says. Explanation for it.
my lord. Far on to the explanation, my lord.
Uh,
If the petitioner,
A frequent situation has arisen in the
Item number 6,
There was one judgment you wanted to point.
Let's try it, handed over to my senior, let's see.
that have gone through it. What I tell them, after this, it's not possible for the coming because I have some document I want to produce before lawsuit to show that why this notice has been issued.
document is asked for. That has not been
No,
provided.
for your satisfaction, I will produce, after research only.
Whether those documents are in your possession.
No, it is, this function officer has come along with us.
I have submitted all the documents. If some documents are available with them, then Lordship it is completely back, that itself proves Lordship.
The entire case is that the notice, how notice has indicated the name of all the ward members of the panchayat.
But there is
Yeah,
already
that
a
is the only-
judgment.
that is the only
He
ground.
cited a judgment. and
That
said-
judgment I have gone through, I am in conformity with the judgment.
Clearly.
Then I'll go.
Yes.
You confirm the judgment, then nothing I have to say.
No,
That is the only.
forgo that you forgo that I have.
Yes, that is my entire case, I am covered by the judgment.
Yes.
Yes, that is. You
So
have not
what-
complied that.
Last occurrence, he was arguing that the notice itself, which contains the notice is along with the requisition and resolution. But he says, how come the notice has indicated the name of all the ward members? That is why considering that notice is illegal because of that.
I still remember 18, 17.
Flagship, that put
Yes,
that put
that is what he was arguing.
Even some of them
In
are
that
not
view, of
there.
that view, of yes. In
You
that
have
view of
given
the
18
matter.
names, but you have not shown it.
Yes, that
So
view
it
of the
says
matter, I
that,
want.
this judgment comes in the play.
That
Non-compliance
judgment is of no help. to
Section
him.
24 to
I
C.
have gone to that judgment.
Mandatory.
So then you argue on that,
No,
when-
after this. After.
next.
Item 7.
Seven.
So I think Kevin, this is not matter of whether the example said that executive officer is a civil post or not, or collector is the disciplinary authority. But you know, typically some judgments are there. Check the all judgments, some other judgments are also there, or asked to the consulting person to comment.
With the judgment.
Some judgments are there, unreported judgment.
You know better.
That I have
What
got.
the department then?
No, that I have got some judgment. But several judgments have been there.
Good.
Several judgments are there holding that the collector is the disciplinary authority.
It reminds me of my being there for.
That has been decided in many times.
What do you want?
Next week.
Next week.
Implement to continuous.
That's there, that is what.
Item number 8.
Yeah, you know. Sir, whenever single judge order starts from page 38, page 37, annexure 8. It also comes down to page 40.
Union of India, anybody?
First, you are sharp. So this batch of writ applications have disposed of on the ground that they have completed well.
Eight.
Eight CA no. No, sir, it is up there, a weekly list. Eight is CA na CA. Union of India.
Yes.
That's the judgment mirror, we have no quarrel about the proposition that whoever completed 3 years of service, their writ application was to be disposed of. That writ application were dismissed, not entertained. Those who have completed 3 years. So far as my case is concerned, and case of another mirror out of the batch, they have completed only 1.5 years. So that's a mistake, mirror, factual error.
Out of these restrictions, I think we have dismissed. Okay. 3 years, we have crossed 3 years.
Yes,
Health groups and all.
The case where it is.
Where these
flag beamer, even those two
at
hours.
the time of batching, you have not pointed it out.
No, we have pointed to that was reflected in order dated 21/5. Where it is a flag B.
Flag B.
Yes.
The physical file. Physical scan, does not scan.
Yes, what you say.
Second copy.
Do you admit that he has not completed cleans?
No, but this is notice has to go to Union of
No, that
India.
is Union of India.
Give a notice.
Well, already served a copy well. Already copied. They have appeared.
I do not know, but PhD is not a peer.
No, they have appeared on two statements. They have appeared in two.
No, we are it was there. He was okay. That's why I remember. He's
Order in your bag, see you, PK file. Yeah. Yes, give him a notice.
Right.
Give him a notice and cover to give.
Item 9.
Heard the matter in study. All my hearing that with regard to interstate seniority between the promoting and direct recruiting.
I have prepared a small compilation. Lakshya to kindly take up the compilation. Small convenience note. Appellant is a direct recruitee of the recruitment year 2011 and has been appointed on 3/3/2016 pursuant to advertising number 5 of 2011. Respondents are promoted to West Group A Junior Branch from ORS Group B on an ad hoc basis by notification letter 17/10/2015 against recruitment year 2015 pending concurrence of OPS. So page marks are here also. The final gradation list was published by the order dated 8/3/2019. In the said gradation list, appellants were placed above the respondents on the basis of the recruitment year. The gradation list dated 8/3/2019 was challenged by the promotees of recruitment year 2015 in WPC number so and so. This Honorable Court by the order dated 29/7/21 directed the respondent promotees to file a press representation along with the judgments before Principal Secretary, Revenue Disaster Management Department, that the page mark is here. Pursuant thereto, respondent filed a press representation dated 15/11/21 directing revision of gradation list dated 8/3/2019 by determining seniority between the direct recruits of the recruitment year 2011 and promotees of recruitment year 2015 on the basis of respective date of joining the cadre. Order dated 15/11/21 was challenged by the appellants in WPC number 36490 of 2021. Said requisition was dismissed by the Honorable Single Judge by judgment dated 5/5/26. Thereby, the determination of seniority between the parties on the basis of the respective date of joining was upheld by following the principle laid down in K. Megachandra Singh versus so and so. The other judgments are here. That the impugned judgment is liable to set aside on the following reasons. K. Megachandra carves out an exception for cases in which the applicable service rules consider the recruitment year as the basis for determination of seniority. 2. In the present case, the scheme of Rule 11 of OS Rules 2011 envisages recruitment year as the basis for determination of seniority. 3. Furthermore, the state has also accepted the definition of recruitment year as the year when vacancy arises. This is evident from the following. A. Corrigan of dated 10/10/2030 to advertisement number 5 of 2011, which provided for a selection to the recruitment year 2007, 8, 9, and 10. Later dated 8/12/2016 issued by OPS URY. Concurrence is given for promotion to the recruitment year 2012, 14, and 15. Moreover, 4. Moreover, the judgment rendered in K. Megachandra has been referred to larger than the Lordships are aware. Now, Lord, the short point if your Lordship will consider the final gradation list admittedly prepared on 8/3/2019. And this gradation list is being challenged after it was finalized before this Honorable Court. So, question is, if your Lordship would see that the Megachandra judgment comes on 19th of November 2019. So here I have gone through one of your Lordship judgment. I have come against that. Where your Lordship in para 2 of your Lordship judgment in Calcutta High Court has dealt with Parmar and Megachandra. And in para 32 of that judgment, your Lordship has in fact saved those gradations which are prepared prior to K. Megachandra coming into in the prospective overruling principle. Your Lordship has been pleased to hold that. So Lordship will let that judgment in. Marker to I'll see para 32 of your Lordship. Your Lordship was dealing with a case here, factually maybe little distinguishable. Your Lordship was dealing with the cases where the promotees and direct recruitees are of the same recruitment year. Kindly see para 32. Now, juxtaposing this to the finding given by the Honorable Single Judge, kindly see just one paragraph. from the improved judgment. One paragraph. Now, rule single just says that the gradation list which was finally published on 8/3/2019, since was challenged at a subsequent point of time, has loses its finding. Kindly see that part of the finding only.
104.
Page 104.
No, this final prediction list of 2019 was a subsequent of challenge at the behest of some of the
Promoters.
promoters. And in that, the expedition was directed to be disposed of, that permitting them to make a representation of the authority to take a revisit.
Right.
That now they have revisited,
The authority has revisited it, referring to Megachandra.
to whatever, revisited.
Yes.
The issues. So it cannot be said to be a final in that sense, because the matter was really made a sub judice by this notion of the representation.
But I can understand if prior to final publication it was subject matter of challenge at the provisional stage, then I can
No,
understand.
I understand, sir. You say when it was a draft, the gradation list.
You had an opportunity of objecting that.
And there is a procedure that it is to be circulated amongst the employees to give any suggestions or make any objections with regard to the position.
Yes.
And once the objection is taken, yes, everything is taken care of.
Kindly see that 8/3 gradation date.
That your contention is that it is
What is the date?
untouchable. It is untouchable.
Rather-
It cannot be interfered with. I believe,
Rather safe,
There has really
rather it's
opened
safe,
the floodgate for that.
rather it's saved by K. Megachandra. K. Megachandra says that your lordship view, para 32.
I know.
Yes. Kindly see thereafter also, my lord. Kindly see thereafter. My lord, kindly see that order dated 8/3/2019. Page 167. Kindly see. Unacceptable. Unacceptable, page 167.
There is no 167 there.
I am arguing that in fact I am pleading writ appeal 824 of 26, the second one.
834 or 834?
824.
834 is mine.
834 is my, I'm sorry, my lord.
Numerically very similar. One.
But 167.
Yes.
Kindly similar. The tentative gradation list of OSA junior branch officers was published.
No, that's true. Inviting an objective. Yes. There is no difficulty.
Now here,
So final publication. That's
Final publication. and in this list I can figure out that we are placed above these promoters, my lord, because our recruitment year is 2011. That is what that is the catch, my lord. That is the catch. Yes. I can understand that, my lord. Then I'll take your lordship to the relevant rules also. Now here, your lordship would kindly see the relevant rules. Page 108. Annexure. Because all
Actually, representation was disposed of, the Honorable Court directed to dispose of representation without considering the merit of the case. That he earlier written. On their contention,
whether
their contentions recorded because we were not party, not the state was heard. So the Honorable Court disposed of this application, directing the state to submit. And their contentions are simply recorded.
whether that destroys
The
the family.
recruitment, you were taking shelter under the definition of a
Recruitment, yeah,
year.
correct,
Where is
recruitment.
that recruitment
You are
year?
page 130. Page 130,
Yes.
rule 11. Interest seniority. The interest seniority of OS Group A junior branch officers in respect of a particular recruitment year shall be in the following order. And in each category, the interest seniority shall be determined in the following manner. Promotee officers shall be ranked interest in the order in which their names appear in the select list. Direct recruit officers shall be ranked interest in order in which their name appear in the merit list prepared by the commission. The interest seniority of the officers in other grades shall be in the order in which their name appear in the select list. Now, your lordship will get the catch in the second line.
officers in respect of a particular recruitment year. Particular recruitment year, further your lordship will be clarified from the corrigendum. Pursuant to the advertisement by which we were recruited. Page 132. Kindly. Here, the candidates were made eligible of the recruitment year 2007, 8, 9, 10 for the recruitment in the year 2011. Kindly see.
What?
Let me place it. Page 132. In pursuance of orders dated 30th of August 2013 of the Honorable High Court in WPC number so and so and other writ petitions, online applications are invited from the candidates who are eligible for the recruitment year 2007, 8, 9, 10 before the amendment rule came into force in 2011. So recruitment year 2007, 8, 9, 10. Why I am just emphasizing this? The recruitment year is the catch here, not the date of recruitment. And recruitment year they consider, the recruitment year means the recruitment word is interpreted by a constitutional bench of the Honorable Supreme Court. That I can cite the judgment. Recruitment starts from the date of advertisement till the actual appointment. So that being the position, here the recruitment year, if a lordship sees, in this rule, recruitment year has not been defined.
No, the year has been defined.
Year is defined.
The calendar year.
Recruitment year has not been defined. The year has a defined calendar year. Recruitment year has not been defined. And K. Meghachandra, interestingly, your lordship will see, those are the cases issue as to the date of appointment. Appointment was the issue there. Recruitment year issue. The rule provided for the seniority on the basis of date of appointment, not the recruitment year. So factually also it is distinguishable. And K. Meghachandra also says, in an exception where the recruitment rules provide otherwise, so this should not be criteria for determination of the seniority. Kindly see that part of paragraph of K. Meghachandra also.
Not only that, any seniority list has already been prepared prior to Meghachandra case, my lord. That has been done. That is saved. And that has been, the lordship has also dealt with that subsequent judgment. See, Hariharan case. Hariharan case has been also quoted that judgment also. In lordship judgment in
para 39 of K. Meghachandra. Para 39. Judgment in NR Parmar relating to certificate employees cannot, in our opinion, automatically apply to the Manipur State Police officers governed under the Manipur Police Service Rules 1965. We feel that NR Parmar had incorrectly distinguished the long-standing seniority determination principle pronounced inter alia. Jagdish Chandra Patnaik, Suraj Prakash so-and-so, Pawan so-and-so, then these three judgments and several others with like enunciation on the law for determination of seniority makes it abundantly clear that under service jurisprudence, seniority cannot be claimed from a date when the incumbent is yet to one in the cadre. In our considered opinion, law on the issue is correctly declared in Jagdish Chandra Patnaik and consequent to disapprove the norms of assessment of interstate seniority suggested in NR Parmar. Accordingly, the decision in NR Parmar is overruled. However, it is made clear that this decision will not affect the interstate seniority already based on NR Parmar.
Yes.
And the same is protected. The decision will apply prospectively except where the seniority is to be fixed under the relevant rules from the date of vacancy / the date of advertisement. The two things are here.
And in our case, the final graduation list was on 8/3/19. That is
Kindly, since your lordship is looking at para 39, your lordship may, it will be beneficial if your lordship would kindly see para 31 also. That relevant rule which was being considered, kindly see para 31. With the above understanding of law on seniority, the provisions of Manipur Police Service Rules 1965 and more specifically Rule 28.1, Rule 28.3 and Rule 16.3 will now bear consideration for ready reference and are extracted. In the case of persons appointed on the result of competitive examination by or by selection under clause B of sub-rule 1 of rule 5, seniority in the service shall be determined by the order in which their appointments are made to the service. 28.3. The relevant seniority of direct recruits and promotees shall be determined according to rotation of vacancies between direct recruits and promotees are determined under rule 5 for that year, and additional direct recruits selected against the carried forward vacancy of the previous year, which will be placed in block below the last promotees as the case may be. The seniority officers so appointed under sub-rule 3 of
There is from the date of appointment, the seniority has to be considered. Yes. But here what you say is from the date of the recruitment here,
Yeah.
the seniority is to be considered. So even in Megachand, the Megachand, actually, that was the matter of consideration. That was the
Manipur service rules. Date of appointment was the criteria.
appointment was.
That was the
Not
rule
the-
also. That was the
That was
rule
the
also.
rule also, not the recruitment year. That will be point before
And
you
I-
ask it for consideration. No? There are private respondents here.
And in addition to it, there is another point also, besides this. The rule clearly says that they have to work for 6 years, the residence period, what we call 6 years residence in the parent cadre. They were given officiating promotion before 6 years. I mean, 5 years when the rule was not, rule provided 3 conditions. One is that they have to work for 6 years. Then the Constitution Selection Board has to be constituted, and PS for Publisher and Commission's recommendation has to be there. Then only the regular promotion, that promotion can be put. So the promotion, whatever was there in the officiating promotion, the promotion order itself clearly shows that it is.
You have not challenged the promotional order.
No, my lord, I have read this. No, my lord, we have not challenged the promotion, but our Gedesili is.
Can you go into that?
No, my lord, my humble submission is.
Improper, the promotion was.
No, I'm not an improper promotion. My case is not that improper. My case is that their seniority will be determined from the date when they are regularly appointed. Regularly said. That is the judgment, my lord. Your lordship, there are the way back in 1990. Sorry, my lord.
Is the only short point which is involved is, admittedly, you participated in a recruitment process initiated in 2011. Though for some reasons, maybe by a legal battle or something, it was not immediately conducted.
Right.
But ultimately, all the impasse were cleared, and you were, and these officers were appointed. Subsequent to the promotees.
Well, promotees, that
Or 17, they were given an
there
appointment.
is a catch. The promotion will be effective from 17 only. Sorry. Excuse me.
They were given a letter of appointment. So, one first thing is that repeatedly they came to be appointed in 2016.
Yes.
But what happened in the meantime, some of the regular employees, by way of a promotion, they were actually promoted in the year 2015.
No, not 17 actually. Their actual promotion as per the law, my lord, will be determined to be 17, not
That
15.
you say that these are the conditions which postulates 6 years of continuous rendering services that the feeder post, then how can they be appointed in 2000?
No, not appointed. They will be treated to have entered into the cadre from the date when they are regularly promoted, my lord. And that is the constitutional judgment of 19.
Their promotion was
On ad hoc basis.
Whatever be the basis, their promotion was in 2015. So the question is that if you were born in a cadre in the year 2011 when the recruitment process was there, maybe for the year vacancies which arose in 2007, 8, 9,
Right.
for the recruitment process which was initiated, your appointment, if I understood, should be considered as an appointment for the vacancy declared in the year 2011 when the recruitment process.
Right.
So it is a recruitment year which would be more relevant and should be considered as the stage when the recruitment process was initiated. Not the date when the actual appointment, because the process is completed on a particular date. In the meantime, if any promotion is there, then they have to be below you.
Right.
and not the you, that's the only catch which we have to consider.
Yes, and they were promoted against 15 vacancies.
Whatever.
Not just 15 vacancies. It is stated so.
It so happened, sir, if the vacancy was there in a particular year, but no recruitment process initiated.
No,
This vacancy is carried forward to a next year. It is again carried forward. On the date when recruitment process was initiated, it will be deemed that it is a cadre of 2011.
no. But they are.
I think that is my judgment. Which
Yes, my yes, my
judgment.
that exactly.
Para 22 of Constitution.
There, the promotion order clearly says that
Now there is a some human among the staff on the other side part to convince my brother.
But because
I hope we have a case for hearing for your lordship, Lord.
private
Respondents are
private respondents are there.
So,
My learned friend is appearing for some of the.
Not by my own will.
Lectures, I will show her probably your lectures were not
Uh,
thrown light on.
I am
that.
still
Can I?
open so to change my view.
Yes.
If I feel that I have committed a wrong, I am bold enough to accept that. But you'll have to convince that I am
Yes,
wrong.
yes, your lordships, I would convince your lordships with much more than your lordships.
This cannot,
Yes, your lordship.
I believe, that's why I'm saying, or if my brother
I would, I would.
not agree with this view, and he has.
Your lordships, we have also a short compilation with you.
Now, what has been there said?
Your lordship.
What is said now?
No, repeat, but they are similarity, the cadets list which has been, where they have treated a senior, that has been confirmed when we are challenging the writ application.
but order.
Case 13, no, 106, the 105 is the ultimate. This is it.
Into judgment. Yeah, that is, yes, they,
No, in his recommendation, because I'm taking up.
let kindly change 104.
No, that's so 104.
Mr. Misra, sir.
Yes, ma'am. That is up to. Mr. 2 at page 110. Relevant procedure, para 7 point, start from para 7.2.
Honorable Single Judge has agreed over para 39 of Megachandra. Kindly see that in my brief subject to para 7 points, sir. Para 7.7 of the impugned judge.
No, I am. Like 7.8 and 7.9.
7.7 will be. 7.8 is the penalty.
Yes, Madam Boy.
Yes,
What if you hear? This is a very interesting.
No, Your Lordship,
that has been-
I would throw light, Your Lordship. In fact, I've read Your Lordship's Calcutta High Court judgment. Very important things have not been brought. Of course, we are not very aware that which kind of rules Your Lordships were really dealing with Calcutta High Court judgment. Of course, we find on the reading that it was definitely not dealing with the rota quota principle. Now, Your Lordships said that. Let me clear what really is, or what does Supreme Court really say when such issues come before the court? What is and how it is to be seen, Your Lordships? Your Lordships, the age-old case laws holding this field, and I would also show what is the field that Parmar judgment holds, what is that field that Meghachandran judgment holds, or any subsequent development. But this, what did the Supreme Court say was this: when such issues come before the court, the first thing that the court has to do is to see the rules. Nothing apart from the rules. First, that's the first thing. So also that applies to the state government. Look at the rules and find whether there is an explicit, he uses the word explicit, I'll take it, Lordship, for the judgment, explicit conferment of seniority on any event prior to date of appointment. And it says it has to be statutorily conferred, not that you try to get it by showing some advertisement, which was done in this case. Unfortunately, not before the single bench, but before this. Anyways, I'll address that. Then, Your Lordships, if the statute is silent,
The rule which governs the field relating to this particular seniority.
yes, Your Lordship, I'll address that.
Show us.
Your Lordship, and the third thing which the Supreme Court stated is that if the rule is silent, which Your Lordship is trying to tell me, then blindly date of appointment should be followed. Now, Your Lordship.
Let us see.
Now, Your Lordships, I have a compilation, Your Lordship.
Which judgment you want me to see?
Yes, Your Lordship. Your Lordships, the compilation. Is it a page number? It's all. Your Lordships, I'll take Your Lordships to page 21, only the relevant paragraph to set the context. Page 21, Your Lordship.
No, that Pawan Tukar has.
Your Lordships, follow it.
These three judgments have.
Your Lordships, I'll come to everything. The problem is that none of these three judgments are being read with its entirety. Your Lordships, just this judgment, I'll just take Your Lordships to para 45. Your Lordships would see, first they say, the effective date of, did Your Lordships get para 45? Which will be at page 35 of that compilation. The effective date of selection has to be understood in the context of the service rule under which the appointment is made. It may mean the date of process of selection starts with the issuance of advertisement or the factum of preparation of select list, as the case may be. Second, interstate seniority in a particular service has to be determined as per the service rules. The date of entry in a particular service or the date of substantive appointment is the safest criteria for fixing seniority interstate between one officer or the other, or between one group of officer and another recruited from different source. Any departure therefrom in the statutory rules, executive instruction, otherwise must be consistent with the requirement of 14 and 16 of the Constitution. Ordinary notional seniority may not be granted from backdate. If it is done, it has to be based on objective consideration and a valid classification and must be traceable to the statutory rules. 4. Seniority cannot be reckoned from the date of occurrence of vacancy and cannot be given retrospectively unless it is so expressly provided under the relevant service rules. Expressly, Your Lordships. Not to be interpreted. It is so because seniority cannot be given on retrospective basis when an employee has not been born in the cadre, and in doing so, it may adversely affect the employees who have been appointed validly in the meantime. Now, given this context,
So much vociferous on this.
Your Lordships,
Then
given
why this observation came to be made?
Your Lordships, very unfortunately,
I'm telling you, please have a question. Why this observation came to be made? This was in relation to, if you please come to page 35, state judgment power. A judgment should not be read in isolation.
Yes, Your
It has to be
Lordships.
read
I
in conjunction
have read
with the
the
facts.
judgment.
Come to page 25. Come to rule 8, which the court was really considering. At the bottom, please come. The rule 8 has been quoted, which was the subject matter there. What it says, seniority where the appointments by promotion and a direct recruitment. The rule which was there, where according to the service rules, appointments are made both by a promotion and by a direct recruitment. The seniority of the persons appointed shall, subject to the following, subject to the provision of the following sub rules, be determined from the date of the order of their substantive appointments.
yes, Your Lordships.
So that's why the court has said that it will not come from
Your
a
Lordships,
adjustment.
may
It
I?
has to be from
Your
a
Lordships,
date of an
Your
appointment.
Lordships, may I say this was a judgment.
I had no
judgment.
reason to deal with that.
Your Lordships, they followed by other. I show the distinction, Your Lordships. Your Lordships, they have been followed by several other judgments. Lordships. The court said, if the rules are silent, there is no question of inferring anything into it. It will be from the date of appointment. And this judgment, Your Lordships, has been followed by several other judgments which are there in my compilation, Your Lordships. Now let us come back to our rules, Your Lordships. And let us see.
Pointing your attention to the rules.
Yes, Your Lordships. Let me come back to the rules.
Please.
Yes, Your Lordships. Now, Your Lordships, I'll give a copy, Your
If the
Lordships.
rule says from the date
Easy.
of an appointment, I think
That case is
court closes the door.
Yes,
I think there will not be
Yes.
there to stand, no doubt about it.
Your Lordships, may I take the rules? Your Lordship will first look at section 2I. Year means calendar year. That means January to December. Then Your Lordships will look at the method of recruitment.
What is the calendar year?
It will be from January to December here. Your Lordship, it is not the financial year here. It is the calendar year from January to December.
Second year there. Then from January to December. Otherwise, there is a Hindi Sambat year. It's also a calendar.
Your Lordships,
I
but
think here also in this state, they must have a different calendar.
no, Your Lordships, here it is referring to, they have not brought anything on record, and neither is the case of both sides.
Just process that I can understand.
it's-
No
Your
problem.
Lordships, we look at rule 4.
Oh.
Subject to the provisions made in these rules, recruitment to different grades of service shall be made by the following methods, namely: A, in respect of post of Group A junior branch, which we are concerned,
with.
yes, as nearly as may be, but not less than 50% by direct recruitment through competitive exam in accordance with the combined competitive recruitment rules 1991. As nearly as may be.
Clear, 50% by direct.
Your Lordship,
50%
there
by
is a
promotion.
reason for why I am reading it completely, but not more than 50% by way of promotion from amongst members belonging to Orissa Revenue Service. Then Your Lordship will look at the proviso. Provided the number of posts to be filled up during a year would be decided by the government from time to time. Now, Your Lordships, very important.
Common thing which every department has to do, identify the number of vacancies which has fallen in that particular year.
Yes, Your Lordships, if Your Lordships lends me your Your Lordships, I want to make my point. Your Lordship, this is the method of recruitment in our state. Let me just complete, Your Lordship. This method of recruitment only envisages a quota system. This is a court of
Anyhow,
fixed.
let us go in that.
That's the crux of the matter, your lordships. That's the
Anyhow,
crux of the matter.
word is
That's why, lordships.
anyhow, we
the
consider
the entire
be
reliance.
understood in the way that if there is a number of vacancies, 50% by a direct, 50% by
Yes.
promotion. That's all.
Quota here.
Anyhow, you
But
call it a
it-
quota anyhow.
This rule does not incorporate a rota system. What was NR Parmar deciding was those OMs we dealt with a rota quota system where there'll be interspacing of people. Here, even if we go by rule 11, they talk about en bloc seniority. Even if two people come in the same year into the service, there's no
There is a
interspacing.
provision relating to placing the persons in a gradation list.
No, I have to go one by one, your lordships. Then your lordships.
We know there are two modes of recruitment.
Yes, your lordships will kindly bear with me. I'm just requesting your lordships to lend me your patience for years. Rule 8, your lordships. The board shall ordinarily meet once a year, probably, preferably, and this is for the only for the promotion. The board shall ordinarily meet at least once in a year, preferably in the month of January, to prepare a list as are held by them suitable for promotion to the next higher grade, taking into account the existing and anticipated vacancies of the year. Then, your lordships, what are the rules they have to follow? Then rule 9, your lordships. The recommendations of the board under sub-rule 3 of rule 7 shall be referred to the commission along with service particulars in respect of all the officers, including the list of concurrence, in the list for its concurrence, including those cases which are not recommended being found unsuitable. The commission shall consider the list received from the service particulars and furnish its recommendation to the government. 10. The recommendation of the commission in respect of reference made to it under sub-rule 1 of this rule 9 shall be considered by the government, and the list approved by the government shall form the select list for appointment to respective grades of the service. Now your lordships may read rule 11. Your lordships, I would come back to rule 9 and rule 10 to answer Mr. Mishra's query, or I mean, their argument that they have advanced. May I just
Yes.
Your lordships will permit me to read rule 11. I'm sure your lordships is a very fast reader. I know your lordships, but sometimes what the council wants to say may have missed if he does not read it off. Then your lordship, after having read all this, the sequence of event as to how the list has to be created for the purpose of appointment, and yes, it is the government's say which is final. The inter se seniority. What does this rule really address? The inter se seniority of the OS Group A officers in respect of a particular year, recruitment year. I will come to that, your lordships. Particular means, in common dictionary means, it has to be common. That means there's a common year. I have a common year.
Specific, it is an adjective, this is used.
Your lordships, I
Notes something suffixing it.
it
to
is
be
particular.
specific.
The use of the word here particular would mean that there is a recruitment year which is common between both the sources. I will show to it from a dictionary meaning to it also. And recruitment year, and I'll come to the definition of recruitment. Shall be in the following order. This is very important, your lordships. Order. And in each category, the inter se seniority shall be determined in the manner. The order first is all the promotees go, and then all the promotees come. Thereafter, all the direct recruitees come, provided that the recruitment year is the same particular recruitment year. And what happens among them is also basically all the promotees take it the way the DPC has recommended. And as far as the direct recruitees are concerned, as where their merit position in their exam is concerned, in between themselves. But the order here is the promotees are first, and then en bloc the direct recruitees are below them. So we don't in this state, at least under this rule, we don't have a rota quota system. I'll come back why I'm emphasizing on this, Your Lordships. That will have bearing to the Calcutta High Court judgment. I'll come back to that. Now, Your Lordships, recruitment is a word which has not been defined here. Not been defined. There are two leading Supreme Court judgments which say this. Is in a 309 rule, recruitment has not been defined. It would mean at least enlistment. That means the end of the recruitment process. At least enlistment. Now I'll show those judgments are there, Your Lordships, in that compilation. That, Your Lordships, will find at page 169. There are two judgments. One is 169, 173. See to say that. And I'll also defer that constitutional bench judgment. It's not really on this point. I was aware of that judgment. Your Lordships will just look at para 16. That will be at page 172. That refers to an earlier judgment, which I have also given in that compilation, which says, Article 309 Constitution empowers the appropriate legislature to frame rules and to regulate recruitment to public service and the post. Recruitment, according to the dictionary, means enlist. It is a comprehensive term and includes any method provided for inducting a person in public service, appointment, selection, promotion, deputation as well method recruitment, even appointment by transfer. But any rule framed is subject to the provision of the Constitution. Now, Your Lordship, I would like to go back to that earlier judgment, which Your Lordship will find in the following page and para 6. And it's quoted at para 6. This judgment is specifically for 309 rules. Your Lordships, there are n number of judgments apart from this, starting from Jagdish Patnaik till here. Jagdish Patnaik case, why is very important? Because this again bears with state of Odisha for similar rules and provisions. And there also the court stated recruitment means appointment. They did not take any fact into consideration prior to the recruitment. They did not say that the date you decide to make a advertisement, that's the date I'm going to do it. Because, Lordships, there are too many things which happen before enlistment. Even if we stretch it to the date of vacancy, then few people here may not have even gone to the college before that day, on the date of vacancy. Now, Your Lordships, may I just, because everything is being hovered around those two judgments. Farmer this day, page 237. May I just show?
Still, I'm holding my me back.
Yes, Your
It's
Lordship.
moving too
But-
fast. But still, I'm holding me back because I wanted to clear my conscience on all aspects.
Your
You are
Lordship,
referring to this Shiv Kumar judgment. You refer paragraph 16 and then say recruitment means an enlist. In what context this was used as an enlist? And what is the meaning of the word enlist akin to a recruitment?
Your
Does
Lordship,
not say that the date of appointment is the date of the recruitment.
Your Lordships,
They were considering the case of a recruitment action. This was not a case of a recruitment year.
Your
So
Lordship,
there they were thinking, and paragraph 7
Your Lordships,
of that particular
may
rule was
may
saying something
may
differently.
say, Your Lordships, may I say this?
Yes.
And I repeat this.
Still because that judgment is hovering in my mind.
No,
That's why
no,
it's
Your
my
Lordship.
own judgment.
That's the
Yes.
clarification that I want to make, Your
Yes.
Lordships. That's the clarification.
So
I
what
want
is,
to-
what
Now,
is-
Your Lordships, in fact, one of the biggest argument which was
So now on recruitment, what more that?
no, Your Lordships. No, let me come back to you. What's hovering, Your Lordships?
No, just tell me, what is the recruitment means? Any other judgment, one says enlist. Let us see what is the meaning of word enlist. And then.
That's the
what
reason
other-
why.
what
That's the
other
reason why.
judgments
Your
say?
Lordships, that's the reason why I read Rule 9 and 10. Because the enlistment happens there.
Oh, yes.
Now that's how I wanted to join it, Your Lordship. Now, Your Lordships, the whole issue.
I believe, it requires a deep.
No, Your Lordship, may I, no,
You're
Your
not what
Lordship,
are you?
Your Lordship,
49 respondents said their argument itself is the ground.
I can fix a particular case, and you can go on an extensive argument.
There are 49 respondents are there. And that means that
I
only for
will
two
still
people
I tell
respondents.
you very frankly,
Your
very
Lordship,
candid.
I,
Though I have taken a
said by
particular
him.
decision in another high
Yeah.
court, but still I feel.
of course, by the time Your Lordships gave that decision, Your Lordships, if would allow me and give me that lending clause, I would throw some light on this, all these judgments, which will definitely make Your Lordships rethink on that issue.
That's true. But
Yes, as Your Lordships is already open. Your Lordships, after the break, please allow me to place
Okay.
NR Parma.
Your Lordship,
Please allow me to
Lordship,
place NR Parma so
Your Lordship,
Lordships will be able
Purpose is satisfied.
No.
Your notice be issued to other respondents. Yes.
I have
Other respondents. Notice be issued.
issued, you are appealing for 2 and 3 people.
Then I have no problem in.
No, I was just looking at for the purpose of an interdiction or the interim order which is to be.
Yes, sir.
Already the list is come.
But for the
Already our list
moment, you are not pressing for any interim order.
The list has come. This is such a debatable point.
Yes.
Which needs a further reconsideration.
Yes.
I am
It is
concerned.
said by
My
hearing.
brother, I do not know.
Your
But I am concerned. We need a further.
Chiefs, I do not know, but with all enthusiasm, I want to throw light on that point.
That's why I say it is something which has to be gone into because had it not been there, my observation or my decision, the position would have been different. But once I have taken a particular view, then I have.
No, Your Lordship,
by my own
maybe
concepts.
certain things were not shown, Your Lordship. Certain things were
Certain
not
things
shown.
were not brought, certain arguments were not made. Had
I'm not
had
talking
those
about
arguments
the
been
calculated
made,
judgment.
will it tilt the entire observation which I have made? All these things have to come to
Yes,
that.
Your Lordship, one thing I want
So
to
what
say.
I
One
propose is
thing,
the notice has to go,
Yes.
but since the publication has already been
Yes.
given, only thing is we'll say the effect has to be stayed for
Your
the.
Lordship,
Yes.
may I just.
Exactly.
We are not disturbing, we are not disturbing the final judge.
Due for a promotion. We are due for a promotion, Your Lordship.
Anything?
May I just say one thing, Your Lordship? May I just say
You
one
can
thing?
also say any further action which has been taken will be subject to the.
Yes, sir,
Yes,
that is so,
yes,
that is so.
Very fair. Very fair.
People say not to give effect if any further action has already been.
That will be subject. Yes.
Just
Very
this
fair.
one thing, Your Lordship.
Very fair. Very.
This writ application was pending, Your Lordship. When this writ application was pending, the tentative gradation list giving us a higher seniority was published and they did not challenge it. They kept quite.
Tentative gradation.
Your
Why is the
Lordship.
question of challenging dictation was pending?
That's exactly where you are arguing.
How can you say we did not challenge it?
He's correct on that.
It did not.
If something has happened which really alters your position
Right, Milord.
during the pendency
So,
of the.
that's the reason you have to be balancing
What you have
between.
not for a protection there.
That was the subject matter also.
Just cannot be altered.
My lord, that was the subject matter
Always
also.
the lispendence theory will not save
So
you.
we are not altering, my lord. We are just saying that your lordship is equalizing the balance. Your lordship is balancing the equity. Your lordship saying that subject.
Was done during the pendency of the writ petition.
That we
Last
don't want to
That was
say.
the subject matter, the writ petition, my lord. That was the subject which we decided. Yes.
So large. But we are not asking to
That was
say
there.
that.
We have challenged that.
Anyhow, we will consider.
All-
Deeply obliged.
Let the gradation list be subject
Give
to
me
result
a
of the.
days. It's an interesting point which I really wanted. And once the pure question of law comes before me, it energizes me more.
Similar, Your Lordships, I share the similar
So
feeling, Your Lordships.
fix, tell me a date so that on that day we will not.
All respondents,
Many are waiting
we say,
and after.
Yeah, Your
In
Lordship,
judicial hours, everybody will jump,
Your Lordship,
including you and Mr. Roy. No, no, and Mr. Mishra also.
that's your Lordship.
These matters are there, not
Your
taken up.
Lordship,
we'll request for a figure.
come to do that, Your Lordship.
We'll request for a special.
But Your Lordship that way. But Your Lordship, my prayer would be this.
Lordship, please, say notice will be there.
Give me a date. In the meantime, the notice.
Yes, madam.
Say to.
Let the gradation not be stayed, Your Lordship. They sat over the matter, Your Lordship.
July
For the timing, if any action is
27th,
taken, then I will-
Reason why I'm
that's 27th of July.
there are enough posts and
Let-
parties
29th here.
can be promoted.
Let it be 29th of July, my lord. 29th of July.
It's not in
29th of July is a Wednesday. 29th of July is a Wednesday. By that time, our notice. Notice will be over. 29th of July, we agree for that. Maybe at 2 p.m. also.
9th of July, Your Lordship, I cannot.
Thirteen.
With the Lordship. This is the. I have challenged the declaration order of this honorable court for designation of the senior advocates. Only short, very short point, may I dear Lordship attention. Only your Lordship see page 25 the advertisement. Advertisement that is published by the registered judicial, page 25, annexure 1. That is advertisement dated 8 May 2024. The High Court of Orissa Cuttack invites application from the eligible advocates to be designated as senior advocate in the prescribed format as Form 2 of Appendix A of High Court of Orissa. Designation advocate, advocate amendment rule 2023. The details are available in the court's website and so High Court of Orissa designation of senior advocate rule 2019 and High Court of Orissa designation of senior advocate amendment 2023. This is the rule 2000. There is this advertisement governed under rule 2029 and amendment rule 2023. The advocates, that is the senior advocate rule. Then according to this advertisement, we have filed our candidatures, everything, and the permanent committee was framed by this honorable court, assessed everything, my lord, and your lordship, annexure 3, I was called finally to appear in the interaction. That is on 7th January 2025 at 4:30 p.m. And I appeared there before worship. And thereafter, annexure 4, 141, that is out of 25. This is 13 candidates were declared as senior advocates, designated senior advocates. But there is no rejection. There is no rejection. 141, page 141, annexure 4. And my name is not there. My name is omitted, eliminated. Only 13 candidates, 13 advocates were declared as senior advocates. And thereafter, I sought for the information through RTI minor. And some informations
were given and some information were not given to me. And the only very pinpoint of this case that they have stated the only this process was done by the secret ballot. The secret ballot was resorted to by the full court, and accordingly you secured less than 9 marks, and that's why your name could not be declared. But my name was not rejected, nothing, and nowhere it is stated that is the names were rejected. Only your lordship come to the page 147. Reply to my 6 only. That this is the only the sole this point in this case. The designation process, you have 147. The designation process has been carried out through voting by secret ballot in accordance with the rule 6 sub-rule 7 of Odisha, High Court of Orissa, designation advocate at senior rule 2019. As no consensus would be reached amongst the honorable judges with regard to the name of the applicant advocates to be designated senior advocate, the applicant advocate who have secured 9 votes or more have been designated senior advocate. This is the mind of things that I challenge this only because I was not provided many information. Only this information was provided to me. And my lordship, see, this is the rule. Now, 19 rule. 19 rule. I'm giving to High Court of Orissa designation of senior advocates rule 2009. Well, lordship come to rule 6 sub-rule 7. Rule 6 sub-rule 7 at page 4. Normally, voting by ballot shall not be resorted to unless unavoidable. The motion shall be carried out by consensus, failing which voting by ballot may be resorted to. In the event of voting by ballot, the views of majority of the judges present and voting shall constitute the decision of full court. However, the senior most judge or chief justice, as the case may be present in the full court, shall not cast his vote. In the case judges present be equally divided, the chief justice or in his absence, the senior most judges present shall have the casting vote. In this rule, my lord, the normally voting by ballot shall not be resorted to unless unavoidable. What about unavoidable circumstances arose? My lord, you say I do not know, and the information was not provided. Only your lordship can peruse in the petitions.
The second sentence is very clear.
Yes.
That the motion shall be
Yes.
carried out by consensus.
Consensus. Yes.
If there is a consensus on all the
Yes.
name,
Yeah.
then the voting should not be ordinarily resorted to.
Resorted to.
It appears from that motion that there was no consensus. Consensus means
Yes.
there will be a unanimous consensus
Yes.
that all the members present in the full court, they should say in one voice or echo that yes, he is there. If there is a dissent, then in that event, the voting has to be secret, voting has to be solved.
In my lord,
This is in a more fair manner.
yes.
That one should adopt. This is what the rule says as well.
But there
I'm happy for you.
there must be decision, my lord.
Passed away item 8, take up to in some other day.
No, let me, the others are waiting for their turns.
No, another is agenda 2 p.m. That's right.
Let us complete the supplementary. We have not been, today is the first day for a bench.
Item 11.
We will go after the
Lordship, I am appearing for the opposite party to family, unavoidable family exigency.
But since there is
No, we have not.
Like, Lordship, I am seeking an adjournment in this matter from on behalf of opposite party.
If you come in a different place, I will tell you when you observe this.
That's why I said that I'll again take your lordship. Well, it's on being successful, on being.
Lordship, I am appearing on behalf of opposite party. I am seeking an adjournment due to unavoidable family exigency. The learned counsel is not able to appear physically, and in fact, he's not available. Any sort date may be given, or this matter may be posted tomorrow, day after tomorrow.
Last date, it was passed over at his instance at the end of the day. And we waited for the entire day.
It was passed over for your and then.
Lordship,
So this cannot be done in this way that you will.
In fact, Lordship, there is no urgency. In fact, this writ petition
That
probably
you
has
feel,
become
that you may feel there is no urgency, but the other side may feel there is an urgency.
Lordship, I have limited power in this matter, Lordship. In fact, I have instruction.
Whatever
This
is
tenders,
there-
both the tenders has been cancelled, Lordship. This rate has become infructuous. This IA has also become infructuous. This
The lordship may hear me since he is making submissions on the merits of the.
no, I know, only instruction I have to intimate the court.
How much time will you take? How much time will you take?
I'll take 5 minutes of your.
5 minutes. Then come tomorrow. He is asking for a matter. Tomorrow is supplementary this first matter. Let it.
Item 12.
It is application to take back the certified copy of the annex 3 and 4 to ventilate it.
What are the certified copies you've submitted?
Annex 3 and
Huh? Annexure
3 and 4.
page. Can you give me the page number?
Yes,
I do not.
29 to 35.
20.
29.
But this is a photocopy. It is not a.
Certified copy file separate.
Yeah.
Where?
This is
Oh.
what
Yes. And that's the only document.
Annex 3 and 4.
Where is the 4?
That is 36 to 46.
Can't you obtain another copy?
No, no.
There,
No, you got 20 pictures, photocopy.
Very difficult.
Substitute.
you will actually direct, you don't need to file uploaded for upload.
The order is dated.
The order is dated
18 to 26.
Oh, to ventilate the grimace before that appropriate. Okay.
Item 14.
Huh?
14.
Item number 14, last 15, also there should be issue notice to the opposite parties. And also to solve a copy and also because for development. For product development, also directed to solve a copy only so that I will take instruction.
Who is appearing?
My lord, I was the counsel in the previous litigation. I have to seek information from the opposite party number 6, so my lord may grant 1 week to seek instruction. Because I was appearing as counsel for them. I do not know if they want to engage me in this.
Already they have withdrawn the case, lordship, because we have met the party because he is operating. That's why lordship, as lordship's direction.
No, he is operating, he is a development authority.
No,
No, my lord. I'm for opposite party 6.
I am existing lordship, the,
No, he is an existing, he is there. And who is I just wanted Cuttack Development Authority. Who is representing?
I am from product development authority.
Yes.
Mr. Swine.
So then we have to hear you.
Yes, my lord, that to solve a copy, solve. I have intimated the authorities, but they have not responded.
They are not responded. So let them respond in this week. Next week we will not hear him.
My lord,
Keep it.
and my lord, if opposite party number 6 appoints me as counsel, then I'll file my proclamation as per the issue.
What?
You received the notice from this court.
My lord, I have no.
Opposite party, number 6.
We have already said,
Huh.
we have served extra copy to my,
Serve a copy.
already
Yes,
served lordship.
yeah.
That's why he is appealing.
He will file wakalatama.
Today only we received the software.
Your name?
What
please give
Vakalat
me.
Nama? He is not sure that whether he will be appointed by the authority or a person. How can he file a Vakalat Nama and seeking a liberty to file?
In case they.
In case. So once you get a nod from your client, then you think of Vakalat Nama, any liberty is granted. You have to file it automatically. It's called the Passover matter, which is next week.
Item number 6, passport matter.
This is the matter also it's covered by the Rajya Act. There is nice, that is senior history. Perhaps he is not, Rappel not gone through the judgment.
Why is that? Sometimes
I am not making allegation.
I have not gone through, I have not gone through.
You are opposing me.
This type of commission I don't expect from.
No, I take it, then legitimate don't.
How can I?
Mr. Dale, Mr. Dale, address the court. Address to court.
No, addressing the state
don't-
council, the conduct of the council, conduct of the government officials.
Mr. Swine.
Mr. Swine, have I told lordship conduct the pictures?
Mr. Dale.
Maybe he will nurture. Whether he has read it, he has not read it, it is his choice.
The intention is not.
It is not that. Never say, you are addressing a court, you address the court.
But I am addressing-
Place your case, this is a judgment which I am relying on. Whether they have followed it, not followed it, we will have to decide. Why we will, this is not actually, this is completely an acquisition. It is not really any kind of a,
My intention was never to accuse
it's
the
an
senior
acquisition,
lordship.
it's an acquisition.
What I was submitting, lordship, kindly understand this. I was submitting because he has taken time to go through judgment. Lordship, let me allow to place first lordship, then he will give a reply. That is my submission. I am not saying he is not competent, he is not so competent to go to judgment. and
Yes,
conduct from the
what
state.
we also heard that you say that he has not read that judgment which has been released.
It took time.
Can you say so? Whether he has read or he has not read, it is he who has to suffer.
So,
For his-
made a statement, I have not gone through judgment.
No.
No, he has not
Then
said
sorry, sorry,
anything.
I am ordering my one lordship. Let me allow to place my case.
Yes, please.
Lordship, here is a case lordship. Lordship, kindly straight I come to lordship and next 1 month with application lordship.
Page, can you, because
Lordship, that is your lordship is holding perhaps read appeal. I am lordship on read petition lordship.
writ petition is,
Read petition.
has come. Well, open and issue. Oh, no use of opening. Is it translated?
Yes. One page.
Yes.
That's it. This is the contents of the notice because the Lordship, section 24 to C, T requirements under law.
Where is the Gram Panchayat Act? What section?
Section 24 of the OGP Act. Two events in this section, Lordship. 24:1 says, Lordship, on the date of no confidence, what would be the procedure that is laid down and under section 24:1. Lordship, before 24:2 says, what would be the procedure prior to Lordship holding this no confirmation?
Yes.
So, Lordship, here I am coming to 24:2. There's one, Lordship. I have no allegation against 24:1, 24:2, Lordship. In convening a meeting, Lordship, in convening a meeting under subsection 1, and in the conduct of business of such meeting, the procedure shall be in accordance with such rules as may be prescribed, subject to, however, the following provisions, namely, Lordship, till that they have not come up the rules, I am not on that, Lordship. Then what are the next mandatory requirement that is starts from rule A, Lordship? No such meeting shall be convened except on a requisition signed by at least 1/3 of total membership of the Gram Panchayat, along with a copy of the resolution proposed to be moved at the meeting. Then B, Lordship, the requisition shall be addressed to the subdivisional officer. Then C is important for me, Lordship, because I am giving emphasis 24 to C. The subdivisional officer, on receipt of such requisition, shall fix the date, hour, and place of such meeting and give notice of the same to all the members holding office on the date of such notice, along with a copy of requisition and the proposed resolution at least 15 clear days before the dates are fixed. So, Lordship, it's section to C.
So this two twin documents have to be given.
My notice is fast, Lordship. Three documents, Lordship.
Correct. So
Notice is fast, Lordship.
correct. You are correct. And notice, and it must contain first is a requisition and proposed resolution.
So, Lordship, this was Lordship before Lordship had referred the matter larger bench. In the conclusion, that 2C is mandatory. It cannot be Lordship interested, it cannot be Lordship honorable larger bench hold Lordship. It cannot be Lordship.
Because we took a view in a pragmatic manner that yes, even if the resolution is given or a requisition has already been given, which indicates that these members have shown no confidence on the sarpanch or a Nayab sarpanch, then in that event, this has to be interpreted in that way. But this larger bench says no.
No.
That has to be separate.
Mandatory. This
Separate.
has to be there.
Separate. Yes.
So, what has happened in this case, Lordship, kindly come, because Lordship kindly see the subsequent.
So, according to you, that this is what they have given a notice
Lordship.
saying that 18%. But the resolution.
70, Lordship. One there, Lordship.
That's true. Yes. Correct.
Lordship.
Serial number.
7.
But the resolution or the requisition which is appended thereto
Lordship.
does not indicate that 17 persons have signed.
Great.
Even some other persons not included in 17, they have signed.
No, that is not Lordship.
That's not there.
Sorry, Lordship. 12 persons they have signed, Lordship. Not new, no standard.
All the 12 persons' name is there in 17.
There.
Last time you said something.
No, Lordship. My submission.
It was because of the sheer carried away with the emotions.
So, in fact, Lordship, that's
Yes,
correct because you are very weak in English, Lordship. One, please, Mr. Sai, let me complete. Lordship, because you are weak in English, Lordship, sometimes, Lordship, our language is not.
No.
Lordship,
You are very clear on what you say.
Sometimes it happens with us, Lordship.
No.
Because also, Lordship, my humble submission, Lordship.
So according to you, this is not in conformity with clause C of subsection 2 of section 25. That's okay.
So my humble, I immediately, Lordship, getting this document, I approach this honorable court. This is not a proposition requisition of what we have taken a notice.
So either this notice is defective or the resolution is wrong, Lordship. So it took Lordship months together to clarify and they file a counter. And the counter was justified, no, the notice is wrong and this requisition is right, Lordship.
True.
True. So that's all Lordship. So my humble submission. So it cannot be the notice is the basis.
Is there any time limit for issuance of the notice?
Lordship. 15 days time is there, Lordship.
No, that is for convening the meeting. 15 days. For issuance of the notice, any time limit is given?
No, Lordship. Here, Lordship, the language says, Lordship, on acceptance of the requisition, Lordship. This is the duty. Number of data applications are coming for Lordship. For fixation of a date, but statutes, because Lordship, the rules is absent. That's why the entire difficulty comes. So
They have come with the many documents, he says.
Grateful, Lordship. Grateful, Lordship.
Let us see that what documents he wanted. And what is his perception about it, sir? Yes, sir, Mr.
Yes. What he is challenging, that is annexure 1 in the application as notice itself.
Yes.
I'm placing the notice itself now.
Yes, sir.
The section rule 24C, it specifically says what.
It's not a rule, it's a section.
Yes, no, section 24C. I'm reading
2C.
Yes. What notice is to be specified?
Correct.
This, I'm reading it.
Correct,
The
sir.
subdivisional officer on receipt of such requisition shall fix the date, hour and place. That is the relevance of the notice. That the subdivisional officer on receipt of such requisition shall fix the date, hour and place of such meeting and give notice of the same to all the members holding the office on the date of such notice, along with a copy of the requisition and the proposed resolution, at least 15 clear days before the date of suit.
Yes.
So 15 clear days is to be given. Date, place, and time is to be indicated in the notice itself. And notice is to be given to all the ward members of the Gram Panchayat. That has been done in this case. Now what he is alleging, that why the name of all 17% has been
Correct.
indicated.
There was no occasion to include the name.
Yes.
Mr. Swai, can't you visualize?
Yes.
I am looking in the perspective of another principles of law.
I am indicating why it is indicated.
No, I am just asking. That's why I am saying that once there is no condition which is imposed in the section to disclose the name of the persons who have sent a requisition or a proposed resolution. Only the conditions are that you have received the requisition and the proposed resolution, and you are fixing a date, time, and the venue
Yes.
where you want to conduct the meeting.
Yes.
And there should be a gap of 15 days. Clear 15 days. So language would have been simple. But if you disclose the name, that these are the persons who have sent the requisition, they have sent also the proposed resolution. And then in view of this provision, I have to convene a meeting. I am giving you a notice. Then if a resolution and the requisition does not tally with what you have disclosed in your letter, can you say that it is a proper notice? Because it creates a confusion in the minds of a member. What they will go and will do it. Who are the members who have taken?
Why it is indicated here? Because it is indicated.
That's why the legislatures were conscious that you need not have to disclose the name. There's no.
No, that is already disclosed because we have to enclose the requisition and the proposed.
Oh, that is what I'm saying. In the notice, you need not have to.
It is within their knowledge. It is within their knowledge because enclosing the requisition itself.
Probably, I think wavelength of our mind is not matching.
No,
I am not talking about the resolution or a requisition.
Yes.
I am saying that there was no mandatory conditions in the notice to disclose the name of the persons who have given you a proposed resolution or requisition. There is no condition. It's not there. But if you disclose of your own And there is a disparity.
No, what we have
There is a disparity in the notice and the proposed resolution and requisition. Then
disclose the entire list of the members. Entire list of the members, all 17, the name of 17 members we have indicated. So that is within his own knowledge. And person, those who have given the requisition, that is also there.
sir, I do not know. I had no occasion to read the original one. But a translated copy which is given to me, from there it says that the following ward members of your Gram Panchayat have brought one no confidence motion.
Yes, that is all the name.
If that is the position, then it appears that these persons, some of the persons have not given, not 17, actually
12.
12 has given.
12 has given. This 17% inadvertently it is written because all the elected, the list of elected ward members are there. After going through the
Sir,
list,
this is the all elected members means you'll have to give this notice to all elected members.
this is the name.
You have to send. These are the person who has given you a resolution or requisition.
What they have indicated, I'm reading it out.
I have read the translated copy. My brother will be able to correct it. Or if you read slowly, I can understand.
I am reading it slowly.
Yes.
I said,
No, please read the notice. What you have said.
Inadvertently, the name of 17% has been indicated, and how the inadvertently has
So
been-
now is it a fatal or it is not a fatal? I'm asking.
I think
Is it directory or it is mandatory?
it is not it is indicating the name of the all ward members is not mandatory.
Correct. So is it not to be taken as a wrong information given by you?
Indicated petition is no way prejudiced. Even
No.
if it is mentioned,
You
how
are
is prejudiced?
you are going to the concept of prejudice.
Yeah. So no way is prejudiced. That has been dealt with in the supervisor on a single judge elaborately. I will place that. Elaborately, all these arguments have been dealt with.
Correct.
Yes. I'm reading it.
So according to you, the division bench will simply give a rubber seal of the single bench judgment?
No, not
Because it has
the
been done
reasoning-
elaborately. So what is the use of the division bench to be constituted unnecessarily? We will go by the rigor of the single bench.
Go by the reasoning of the learned single judge, and I will also place this. ଏତ ଦ୍ୱାରା ଜଣାଇ ଦିଆଯାଉଛି ଯେ ଆପଣଙ୍କ ପଞ୍ଚାୟତର ନିମ୍ନଲିଖିତ ୱାର୍ଡର ସଭ୍ୟ ଓ ସଭ୍ୟାମାନେ ଯଥା
Jotha means,
ସଭ୍ୟ means
I know, sir, I understand
yes.
that I am hereby informing you that
Following
the following members and the madams or the female members, then Jotha means namely, yes,
then 1, 2, 3, 4 they have indicated name of the 17 persons. ଆପଣଙ୍କ ବିରୁଦ୍ଧରେ ଏକ ଅନାସ୍ଥା ପ୍ରସ୍ତାବକୁ କାର୍ଯ୍ୟକାରୀ କରିବା ନିମନ୍ତେ
against you they have taken a resolution. Then
କରିବା ନିମନ୍ତେ ଗତ 25/7/2025 ତାରିଖରେ ଏକ ଦରଖାସ୍ତ ନିମ୍ନ ସ୍ୱାକ୍ଷରକାରୀଙ୍କ କାର୍ଯ୍ୟାଳୟରେ ଦାଖଲ କରିଛନ୍ତି. So they have also given the date that 25/7.
So they have submitted in the office on that day. Then
and that has also been enclosed with the
so see Dakil Korishanti. Then
ତେଣୁ ଆପଣ 3/9/2025 ତାରିଖରେ ଗ୍ରାମ ପଞ୍ଚାୟତ କାର୍ଯ୍ୟାଳୟ ଦଳେଇ ସାହି ପରିସରରେ ଥିବା ସଭାଗୃହରେ ଦିବା 11 ଘଟିକା ସମୟରେ ଉପସ୍ଥିତ ରହି ଅନାସ୍ଥା ପ୍ରସ୍ତାବ ସମ୍ବନ୍ଧୀୟ ସଭାରେ ଅଂଶଗ୍ରହଣ କରି ନିଜର ବହୁମୂଲ୍ୟ ମତଦାନ କରିବା ପାଇଁ ନିବେଦନ କରାଗଲା.
So you have fixed the date, time and venue.
Venue we have given.
That is in Karjalaya means the office. You have already said.
We have indicated
Where?
all members. So now, as for this,
Why you gave 18 names, 17?
that we have given because for that purpose I was asking in the morning time. The reason why we have given, I'm filing an affidavit to that respect. Why we have given this? Inadvertent mistake. Because
That I perceived it. Inadvertent mistake.
Inadvertent mistake, and what he has given he has given the list of all elected members which have been declared by the election commission in the same serial he has indicated here, because notice has to go all the ward members. Keeping in mind that notice has to go all the ward members, he has noted all the name of the all ward members. That is the mistake he has committed. And it is inadvertent mistake. And how he is
And the mistake is when he says that these are the members,
that he could have written.
namely blank, 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 blank,
Yes, that
have submitted a requisition
Yes.
showing a no confidence against you. Does it mean all the members of the ward?
What the logic is saying, that part I do admit that is inadvertently that has been done. So my submission is, he is no way prejudiced by this because the resolution and requisition has been attached to this. And he has received it, he has participated in the no confidence motion. No confidence motion out of 17, 15 members have voted against him.
Sir, you argued,
15 members.
what you are arguing was accepted by us.
Yeah.
That it is the intention which is paramount. If the intention to percolate a message that I have no confidence in you as a sarpanch, then these formalities should not be taken as the mandatory provisions. That was our view, which you are arguing. That has been overturned by the special bench.
That is with regards to whether the requisition resolution is to be.
Sir, what is the object of a resolution, proposed resolution and a requisition?
That he should know.
Requisition is that we, the following members,
Yes.
we show our no confidence
On you.
on you,
Yes.
and we wanted you to be removed.
Yes.
What is the proposed resolution?
That is there in the answer.
I am asking you, what is the proposed resolution?
The resolution.
Same thing,
Same
that
thing.
we wanted to propose that you should be removed.
Yes.
Then we heard that it is a mere farcical because the intention is, according to this clause C, that they have shown their the decision that I have got no confidence in Sarpanch. That's enough.
Yes.
Special bench did not accept that.
No.
He says, no, you have to give a separate proposed resolution and a separate requisition,
That has been given.
which has.
So this same
Mr.
person.
Sai, are you not understanding? Then I am at loss.
No,
With deepest of respect.
the what who are elected, they impressed upon that they do not have the confidence on Sarpanch. So falana persons.
Yeah.
So how can they vary? How can their names be varied in the notice and requisition? That is the whole crux of the matter. Here 12 persons, there's 17 persons, and name did not match. Who are the persons who reposed no confidence? Who are the persons? By name we have to call out. That is what since yesterday we have been.
Only ex-
No, if
Name
this is
is
mandatory
not-
condition, then why not the notice intimating that these persons have shown is mandatory? Then we'll have to take it.
So
in
who
that.
are those persons? That is important now. Out of 25, 30, whomsoever, 1/3.
Yes.
So who are they? That their names doesn't match.
No, it is matching. Only here 12%, here 17, extra 5 names are there.
There lies the difference.
Extra all name of.
There lies the difference. So basis of notice goes.
Notice.
You have not rectified.
The
You have not issued any corrigendum.
No, what I submit, Millers.
Now we are saying that
2C specifically says that time, place, and venue is to be indicated there and fixing 15 days clear notice period. That has been dealt with and that has been given. There is no grievance with regard to that. But the extra thing which we have written, it is not necessary to be written here, but that has been written.
Show us the law.
That's
Show
what-
us one judgment. Show us the judgment.
My lord.
Show us any judgment that inadvertent mistake is a complete excuse, and the mandatory provision should be read in that way.
So the mandatory, my submission is.
So that's the special bench that I am breaking my head to a solid rock ice. That what you are arguing that we also perceived and accepted. We held so in our judgment. But since there was a conflicting judgment, we referred the matter to a larger bench. Now the larger bench says our contention or our finding, our view was not accepted. It says not a good view.
So that's why we are bound to accept
only one line I want to distinguish that order with this, because in that case, the full bench judgment says that these are the mandatory things has to be complied with. So we have complied all the mandatory requirements.
Sir, today suppose A, B, C, D, E, F, G have come. They have given requisition. Tomorrow in the notice you will say P, Q, R, S, T, U, B, W, X. They have given the requisition. This is the notice. Can you say that?
That I do admit.
Sir, this is what happens, sir, here. This is what happens here.
But
this is the simple thing happened here. So you have not issued any corrigendum. That what are you arguing against your requisition, against your notice, against your action?
That was
that
was not difficult. But that could have been done. After receiving notice, he has not made any objection to this. He has participated. And the other person, those have appeared, other board members, they have also said there is no objection to this. Now, after losing the case, he is making all sorts of allegations. Technical things also. But the two is specifically my only submission.
But that goes to the root of the matter.
The root of the matter, my only submission, the distinguishing factor is we have complied everything mandatory requirement, but in extra we have written the names, which is not matching with the requisition. But the copy of the requisition is there for him.
And the authority who has issued is a very competent senior officer. He should be very meticulous while issuing notice of such nature. He is not he is not group D as you as you argued in the first half.
And how this has been dealt with by one single, I have this one paragraph. Paragraph 10 and 11, page 37. Page 37 of the deductive typology. On perusal of Annex 2, it reveals that the required number of ward members signed the same, and it has been in accordance with Section 24 of the Act, and therefore rightly entertained by the number 3. It is not that all the 17 ward members of Gram Panchayat signed the requisition. No, any discrepancy is revealed from Annex 2 and 3. It can be said that 1/3 of the total members of Gram Panchayat heard the resolution, that is answer 3, and submitted the requisition to the appeal body number 3. The plea of the petitioner on such grounds alleging discrepancy in so far as the resolution and requisition is concerned cannot be entertained and hence liable to be rejected. Then by 11, the question relates to exercise of power under Section 24(2) of the Act by appeal number 3, and whether he in any way aid while issuing notice, that is Annex 1, for the special meeting to be held vis-a-vis the motion. Law is well settled that 24A and C of the Act are to be complied with, which means the sub-divisional official shall have to send copies of the resolution and requisition to the Sarpanch and Naib Sarpanch, as the case may be, against whom a decision has been taken by the ward members of the Gram Panchayat. A motion to remove him from the post is claimed. It is claimed by the petitioner that notice that the Annex 1 has not accompanied resolution and requisition. Notice as per Annex 1 is signed by appeal number 3 on 8th August 2025, indicating therein that no confidence motion was received from the ward members, and accordingly fixed 3rd September 25 as the date for special meeting to be held. Further, clear 15 days was allowed before the meeting was convened. Therefore, if in case notice as per Annexure 1 was received by the petitioner, there was plenty of time for her to respond to the same. According to section 24A and C of the Act, the subdivisional officer on receipt of requisition shall give notice of them to all the members holding the office on the date of such notice, along with copy of the requisition. Apart from that, the aforesaid notice shall be sent by post under certificate of posting and a copy thereof to be published in the notice board at least 7 days prior to the date fixed for the meeting. In the case at hand, opposite party number 3 is said to have sent notice to all the ward members, and in support of such claim, information regarding postal service as at Annexure DY3 to the counter affidavit is referred to. No member of Gram Panchayat raised any question having not received the copy of the resolution and requisition when the notice of the motion was served at the instance of the opposite party number 3. The petitioner did not raise any objection either immediately after receiving the notice. The notice is said to have been sent to registered post to all the ward members. When it is pleaded by opinion number 3 that the notice has accompanied the resolution requisition, it is for the petitioner to demonstrate as to how such notice was received without the same. A valid claim with any such plea of having not received the resolution and requisition by the petitioner without any such material on record to demonstrate cannot be believed. It is not admitted anywhere by the opposite party number 3 that the notice was not served on the ward members. The postal service with all such information as Annexure DY3 sufficiently indicates that notice have been sent to all the ward members and received by them in time, well before the special meeting was convened. According to the court, there has been no prejudice as such caused to the petitioner as notice was served on her in time and before 3rd September 2025. And not only that, she herself participated in the motions. Then after 15 clear days notice, and they said that notice has already been 15 clear days notice has been given, that has been held.
Yes, yes, yes.
Yes. And this point, it was raised in paragraph 8. That depending on my submission, thereafter that has been dealt with. That paragraph 8 means that Mr. Swain on an AGA for the state refers to the counter affidavit and submits that action of the opposite party number 3 is perfectly justified and including notice. Annexure 1 was issued in accordance with law upon receiving the requisition, that is Annexure 2, based on the decision by resolution, that is Annexure 3. And all the ward members, including petitioner, have been served with the notice sent along with the copies of the resolution and requisitions, and therefore it cannot be faulted with. It is submitted that 12 ward members signed the resolution and not all 17. The same is revealed from the record, and therefore the claim of the petitioner on any such ground alleging discrepancy vis-a-vis resolution Annexure 3 is found acceptable. The contention of Mr. Swain on is that ward members in majority lost confidence in the petitioner and hence passed the resolution, and it was followed by the requisition that the Annexure 2, which was the foundation for opinion number 3 to issue notice and rightly fixed the date of the conference. Then The OP number 5 to 7, those are the ward members, they have appeared before the Honorable Court, and Mr. Agrawal, the senior counsel, for the OP number 5 to 17 would submit that 12 ward members who are more than one-third of the total strength of the Gram Panchayat submitted the requisition along with a copy of the resolution dated 25th July 2025. And accordingly, opposed party number 3 acted upon the same and held the special meeting. It is further submitted that the such meeting was held on 3rd September 2025, in which 16 ward members participated, including the petitioner. Out of 17, in total, the result was declared on 18th October 2025. Out of them, 14 ward members voted against her, and it has been duly notified by the opposite party 2 and refers to a copy of the notification plus one. So the contention is that there is no illegality committed by OP number 3, who all followed the procedure prescribed under law and even sought for the authentication of the signature appearing on the requisition and accompanied it with the assistance of the OP number 4. And upon satisfaction, the list at that requisition, the requisition is genuine, proceeded to fix a date for the motion, and finally it was held on the date fixed. Hence, informed notice that the answer 1 cannot be challenged, and it has not on any such ground advanced to the side of the petitioner. Then on failure of the answer 2, it is revealed that the requisite number of board members are signing the same, and it has been in accordance with section 24 of the Act.
Yes.
Now, from the date of notification, 8th October 2025, he is not holding the office of person. And the Naib Sarpant is not mentioned.
That's all?
And submission, we have complied with the mandatory provision as per the court decision. But in addition to that, we have indicated the name of all the ward members, keeping in mind that notice has to go all of them. But wrongly, that is indicated that the requisition has been given by them. That is it. In other countries, that has been written, which will no way prejudice the petitioner because the requisition and resolution both have been annexed to it. And it is here that he has received, nobody has complained.
Anything you want to say?
Lordship, I think still, Lordship, my friend has admitted that they have done it. But one thing I will So one thing I tell our Lordship, what my learned senior made this point is first time we are making raising before this one, what is not correct, Lordship. They served the copy, Lordship, on 16/8, Lordship. Immediately we have approved this one on 18, disclosing the said resolution requisitions that this is not proper requisition as per the notice. Please supply us proper requisition. Still they are insisting, no, that is the requisition. But first time in this reform court are admitting, they have done it in anonymity. That is my submission, Lordship. This notice and the document.
Total elected are 17.
17 years.
One is not elected.
When,
That is why.
Dead, Lordship, dead. One is dead.
when ultimately the meeting was held when?
Lordship,
3-8.
3, Lordship, on 3, 3-9.
Please.
How many members were present there?
Lordship, that record will say, Lordship.
I have indicated, judgment itself it is indicated that all members are present out of on third supervision in which 16 ward members participated, including the petitioner, out of 17 in total. And result was declared on 18th October.
So one was absent. One
One
was
was-
absent.
Yes,
Out of 17, one was absent.
one was absent. So
So
16
16,
were present.
and he was also there in the meeting.
He was also present.
I'll be
And
there, Lordship,
14
because I had
14
applied
members even voted
after
against.
making stay order. So that's why, Lordship, I am bound to appear, Lordship.
And
I have
14 members are
They
all
on
against
18
him.
I have applied.
Out of 16, 14 are against him. So entire
All
all
are set up.
members are against him, except only 2. All are.
That's all.
Lordship.
Thank you.
Lordship.
One thing is, he does not issue. On the office part. The other ward members are also parties. But I'm stable admission decision before those. Then.
Good. Yes, I have got.
One line.
Oh, you have added many lines.
No, only one line.
What more? Nothing.
That's
Now
one
we
line.
were in a process of understanding that what decision we should take.
But that's not
So
Lordship.
that's all.
I'm not Lordship. And that Lordship, that is the Lordship prerogative. But
Yeah.
one line, only I can add Lordship. That's one line. Because I will have to declare a good judgment Lordship. Lordship, because that is the required Lordship under that. Because proper judgment Lordship. Only Lordship. Here Lordship, there are two provision of law under section 24 to C and D for mode of service Lordship. C says notice along with resolution and requisition. D says Lordship only notice to serve. And the time guidelines also different Lordship. In one is 15 days, in other is 7 days. D says only for notice not of the requisition. E says Lordship, if the notice is not served, then that cannot be ground to invalidate the meeting. But here Lordship, the case is Lordship, kindly Lordship, the cost of liquidation, I have given translation copy. The sub-collector says the following 7 members have signed for requisition. And that has never
You
been.
have exceeded one line.
Lordship.
What submission he has made, that is in 24E.
That gives him an encouragement.
Yes, 24E.
The moment you
What
say
submission he has made,
that
is
will
in
give him
24E.
an encouragement. That is the whole problem.
Lordship, what is difficult? Case is not important, Lordship.
Yes.
To make law proper, Lordship, that is understanding of that is very
True.
important.
That is true.
Because Lordship, we are feeling agreed with this strong understanding of this. Because their understanding
Only one line I want to point out.
we are not
24E.
concerned with the law. Case, head of the case, Lordship.
Section 24E.
You should understand the
1 minute only. 24E. That is, C we have already placed the subject officers one. So D says that the aforesaid notice shall be sent by post on certificate of posting. Then E, the proceeding of the meeting shall not be invalidated merely on the ground that notice has not been received by any member. So even if notice has not been received in early, then also the motion will stand.
So where is this point?
There is nice
It's
understanding.
not. The special bench has already considered E.
Let's lordship, that's ousting a elected member, then they're engaging a member who is.
I have seen the Nayab Sarpanch and the Sarpanch, I know.
No,
There was.
person who is.
He is just selected, I know.
But he's come to me, but the setup.
Whatever, I know. But there are 2-3 judgments which are there which have taken.
Democracy.
Anyhow. Anyhow. I believed I said in the morning that the moment I do not complete the roster, there will be a complete mentioning at the time of rising. And all the blame should go to they consumed more time to argue. Which withdrawal? Which one?
57. 58.
Sir? Who is withdrawing? Tell us.
58.